Every viewer needs to know today's major U.S. immigration update, a policy change effective January 21st, 2026, that will reshape how the United States processes visas, especially immigrant visas that can lead to permanent residency. This is not speculation. These details are drawn from confirmed news reporting from major outlets. In a move announced this month, the U.S. State Department has declared an indefinite suspension of immigrant visa processing for citizens of 75 countries across the world. This policy will begin on January 21st and does not currently have a set end date. Under the directive, consular posts around the world will no longer issue immigrant visas. The category of visas that includes family-based, employment-based, and other immigration pathways leading to lawful permanent residency for nationals of these designated countries, while the government conducts a comprehensive review of immigration procedures. The decision is part of a broader shift in U.S. immigration policy under the current administration aimed at tightening controls and limiting new permanent immigration. Officials have said the suspension is intended to reassess how the U.S. screens visa applicants and to prevent the entry of individuals deemed likely to become dependent on public assistance or a public charge. Government statements emphasize a focus on ensuring new arrivals are financially self-sufficient and not an undue burden on American social services. This policy only affects immigrant visas, those routes that lead toward a green card and eventual permanent residency. It does not apply to non-immigrant visas such as tourist visas, business visas, student visas, or temporary work visas like H-1B or L-1, which remain open and continue to be processed under normal procedures. That distinction will be critically important for anyone planning short-term travel, study, or work in the United States. Among the 75 countries whose nationals will have immigrant visa processing paused are nations across multiple regions, including countries in Africa, Asia, the Middle East, Latin America, Eastern Europe, and beyond. Reports list nations such as Afghanistan, Bangladesh, Brazil, Colombia, Egypt, Haiti, Iran, Iraq, Nigeria, Pakistan, Russia, Somalia, Syria, Thailand, and Yemen, among others. The list is wide and includes both nations with large immigrant populations and smaller states with historic ties to U.S. migration. Under the policy, consular officers are instructed to refuse immigrant visa applications from those countries, even if a visa has already been approved but not yet printed. There are limited exceptions for applicants who hold dual nationality with a passport from a country not on the list, or in rare cases where entry is deemed in the national interest of the United States. Officials from the administration argue that these measures are necessary to stem what they describe as abuse of the immigration system and to protect American taxpayers. They claim this pause will allow the State Department and U.S. Citizenship and Immigration Services to strengthen vetting, tighten financial and background reviews, and ensure that only applicants meeting new standards of financial independence are admitted permanently. Critics of the policy, including immigrant rights advocates, legal experts, and some lawmakers, have sharply criticized this sweeping action as effectively constituting an immigration ban on millions of people seeking to enter the United States lawfully. They argue the move disproportionately impacts Black and brown nations, disrupts family reunification, and undermines long-standing legal immigration pathways that have existed for decades. They warn it could block hundreds of thousands of legal immigrants annually from securing permanent residency. Importantly, for people already holding U.S. permanent residency, commonly known as a green card, this policy does not automatically strip you of your legal status. Lawful permanent residents retain the right to live and work in the United States. However, immigration lawyers are warning that under the current enforcement climate, green card holders should be cautious. Extended absences from the U.S., failure to maintain clear ties, lapses in tax or legal compliance, or misunderstandings of residency requirements can increase the risk of status review or even loss of residency under existing law. Changes over the past year have already introduced more stringent checks on green card holders, including tighter rules on reentry after long travel abroad, renewed scrutiny of eligibility for naturalization, and enhanced verification of marital status for family-based applicants. Experts say that while these are separate issues from the current visa pause, they form part of a broader enforcement and compliance environment that green card holders should be aware of throughout 2026 and beyond. For prospective immigrants, Those waiting for family-based visas, employment-based residency, or diversity lottery selections, this new policy means indefinite delays. Many will have to wait until the suspension is lifted for their country or seek alternative non-immigrant pathways if eligible. Employers sponsoring foreign workers for permanent roles may face significant disruptions, requiring strategic planning and legal counsel to navigate an uncertain processing landscape. For students and temporary workers, however, the landscape remains largely unchanged. Non-immigrant visas continue to be available, and education institutions, employers, and exchange programs will likely see continued demand. Authorities emphasize that these categories remain open precisely because they do not directly lead to permanent residency, which is at the center of the current policy shift. Observers note that this development is part of a longer trend in U.S. immigration policy in recent years. The administration has already undertaken several restrictive measures, including expanded travel bans on certain countries, heightened public charge enforcement rules, suspension of asylum processing in many instances, and an overall reduction in refugee admissions to historically low levels. Deportations and voluntary departures also outpaced new arrivals in 2025, resulting in a rare negative net migration figure for the United States, according to research institutions. On the ground, consular officers around the world are preparing to implement the visa pause beginning January 21st. Applicants from affected countries have been advised not to submit new immigrant visa paperwork until further guidance is issued and to consult legal professionals for specific advice. Some are exploring dual nationality options or alternate visa categories where eligible. Experts caution that while this policy may remain in place for an extended period, it does not equate to a permanent ban. Immigration attorneys note that cases already in progress may still be legally active, even if processing is delayed. They stress the importance of seeking professional guidance and complying with all requirements to preserve eligibility for future processing when or if the suspension ends. In summary, the U.S. has launched one of the most significant restrictions on legal immigration in recent years by indefinitely pausing immigrant visa processing for citizens of 75 countries, effective January 21st, 2026. This affects family and employment-based paths to permanent residency for millions of people worldwide while leaving temporary visas intact. The policy underscores a broader shift toward more restrictive immigration enforcement and tighter vetting standards. Green card holders keep their status, but must remain vigilant about compliance and residency rules. Prospective immigrants and families will face uncertainty and long delays as the U.S. government reassesses procedures and standards for future admissions. This decision is already creating real-world consequences beyond official statements and press briefings. For many families, this pause means continued separation with no clear timeline for reunification. Applicants who have spent years following legal procedures, paying fees, submitting documents, and attending interviews are now facing an open-ended wait. The uncertainty is especially difficult because there is no official deadline or review date attached to the suspension, leaving people unable to plan their futures with confidence. Immigration attorneys report that inquiries have surged in recent days, particularly from applicants who believe they were close to final approval. Many of these individuals had already resigned from jobs, sold property, or made financial arrangements in anticipation of moving to the United States. With immigrant visa processing now halted for their countries, those plans are on hold indefinitely, creating financial strain and emotional stress. The policy also has ripple effects inside the United States. U.S. citizens and lawful permanent residents who have petitioned for spouses, children, or parents abroad are among those most affected. Family reunification has historically been a cornerstone of the U.S. immigration system, and delays in this category are often felt most acutely because they involve immediate relatives. Advocates argue that prolonged separation can have lasting psychological and economic consequences for families on both sides of the border. Employers are also paying close attention. Many U.S. companies rely on employment-based immigrant visas to fill long-term specialized roles. While temporary work visas remain available, the suspension of immigrant visas complicates long-term workforce planning. Employers who expected to retain foreign employees permanently may now need to reconsider contracts, sponsorship strategies, or business expansion plans. From the government's perspective, officials frame the move as a necessary pause rather than a permanent closure. They argue that the immigration system has become overstretched and requires reassessment to ensure that new permanent residents meet updated standards related to security, financial independence, and compliance with U.S. laws. The administration maintains that the goal is not to eliminate legal immigration entirely, but to narrow and control it more tightly. However, critics counter that an indefinite suspension functions in practice much like a ban, regardless of terminology. They point out that even temporary pauses can last years, and that policy reversals often depend on political shifts, court challenges, or changes in administration. Legal experts note that while the executive branch has broad authority over visa processing, prolonged suspensions may face judicial scrutiny if challenged in federal courts. For green card holders already living in the United States, the announcement has prompted renewed concern, even though the policy does not directly target them. Immigration lawyers emphasize that permanent residents should remain mindful of existing rules, particularly those related to travel and residency. Extended stays outside the United States, weak ties to the country, or failure to meet tax and reporting obligations can still lead to questions at ports of entry or during future applications for naturalization. There is also growing awareness among green card holders that enforcement priorities can shift quickly. While no new rule has been announced revoking permanent residency en masse, the broader climate of stricter oversight means that compliance matters more than ever. Attorneys advise permanent residents to keep documentation organized, maintain a clear U.S. address, and seek professional advice before making major travel or residency decisions. For individuals considering applying for U.S. citizenship, the current environment underscores the importance of timing and preparation. Naturalization remains available to eligible green card holders, but processing times and scrutiny levels can fluctuate depending on policy priorities. Experts recommend ensuring all eligibility requirements are clearly met before filing, especially in a period of heightened enforcement. Internationally, the decision has sparked diplomatic conversations. Some governments whose citizens are affected have sought clarification from U.S. officials, while others have expressed concern over the breadth of the suspension. Immigration policies often intersect with foreign relations, trade, and security cooperation, and prolonged restrictions can influence bilateral relationships over time. The situation also highlights the difference between immigrant and non-immigrant pathways to the United States. While immigrant visas are paused for affected countries, temporary visas continue to operate under existing frameworks. This distinction may lead more people to pursue short-term options such as study, business travel, or temporary employment, even if their long-term goal is permanent residence. Legal experts caution, however, that temporary visas come with strict conditions and do not guarantee a future path to a green card. Community organizations and advocacy groups are mobilizing to provide information and support to those impacted. Many are emphasizing the importance of avoiding misinformation, as rumors and exaggerated claims often spread quickly during times of policy change. Accurate guidance, they stress, is essential for people to make informed decisions and avoid costly mistakes. Looking ahead, much will depend on how long the suspension remains in place and whether exceptions or adjustments are introduced. Past immigration pauses and bans have sometimes been modified after legal challenges or public pressure, while others have remained largely intact until replaced by new policies. Analysts note that immigration law is one of the most politically sensitive areas of U.S. governance, and shifts can occur rapidly depending on domestic and international factors. For now, the immediate reality is one of delay and uncertainty for immigrant visa applicants from the affected countries. Families wait, employers adjust plans, and legal professionals prepare for a prolonged period of case management without clear timelines. While the administration insists the review is necessary, the human impact of the decision is already being felt across borders. In the broader context, this development reinforces a trend toward a more restrictive approach to permanent immigration, even as temporary mobility remains available. It signals a recalibration of priorities within the U.S. immigration system, placing greater emphasis on control and selectivity. Whether this approach will achieve its stated goals or generate further legal and social challenges remains to be seen. What is clear is that anyone connected to the U.S. immigration system, applicants, families, employers, and permanent residents alike, must stay informed, cautious, and prepared to adapt. Policies may change, but the consequences of misunderstanding them can be long-lasting. As this situation continues to evolve, accurate information and careful planning will be essential for navigating an increasingly complex immigration landscape.